All right, sorry about the delay, everyone. We had to finish up a hearing or bench trial. So, this is the detention docket for the 323rd District Court for Friday, June 22nd. It applies with the Texas Supreme Court Emergency Order number 33 related to the coronavirus. We are not proceedings. However, we are using Zoom. And to comply with the Texas Open Courts Act, we are conducting these proceedings broadcast on YouTube for the public to observe anything that occurs in a public courtroom. This is, however, still a court hearing. The court does expect people to behave appropriately for court, so please do not lay down. Do not have bright lights behind your head that shadow at your face. Do not use the restroom, take showers. Do not eat or consume alcohol or smoke while you're in court. Also, please do not having moving backgrounds like being in a moving vehicle. Do not have domesticated animals across the screen. The court does also expect people who are not officers of the court to have their cameras on and participate and observe. If you are simply here to observe only, please go to the YouTube channel. That means iPhone. Please do turn your camera on. I believe we have, see, the rest of it are officers of the court. So, okay. iPhone, you need to turn your camera on. Okay. You go to remove iPhone.
Judge, I believe that is Rafael Sierra on the iPhone.
Yeah, he needs to learn to change his name on Zoom or turn his camera on. All right, so we're going to go and start with Damian Elliott. All right, Ms. Elliott, I'm Judge Kim. This is a detention hearing. The purpose of the hearing is for me to decide whether to keep you or release you. If I keep you, you have to see a judge every 10 days while you're here. You have the right to remain silent. You have a right to an attorney. And we have appointed Mr. Adler as your attorney on this case. Damon, let's see, you're 15 years old. So you're 15. Back last July, you were found delinquent and you're placed on probation for burglary of a habitation. Wait a minute. 2 days ago, you were placed on probation for burglary of a habitation. And then, what, yesterday, White Settlement Police brought you in. At Brewer, there's a call about an assault on campus. When they got there, they met with a victim. So she was walking in the hall, saw a friend sitting next to Damian, another male. She went to say hello when Damian started aggressively towards her, punched her twice in the chest with a closed fist, and said, "You were talking all that shit." Then went back up to the victim, grabbed her hair, and pulled it downward, causing her neck to whip, causing more pain. So she went to the AP. She gave you a drug test, and you're negative. All right, so who's here for the probation for Mr. Elliott?
That would be me, Your Honor.
All right, so Ms. Lopez, like, I'm trying to figure this out. How, well, I mean, it's 2 days that he's on probation, he gets arrested for something else.
Right, Your Honor. He was apparently just adjudicated on the 20th and placed on probation until his 18th birthday, and the incident happened yesterday.
So this is an indeterminate sentence probation?
Up to his 18th birthday, Your Honor, for the burglary.
What, was it a determinate sentence probation or indeterminate? Do you know?
Indeterminate, Judge.
Indeterminate.
Mr. Adler, were you his attorney on the previous case?
Yes, Your Honor, and I'm also his attorney in Dallas County with some pending charges.
Was he in custody?
No, Your Honor. Ms. Rodriguez was his intake probation officer, Judge.
What are his offenses out of Dallas County?
criminal mischief off the top of my head, and the more serious one is burg of a building, I think it is.
You know if that offense date was before or after the one he's on probation for? It was July of 20 is the offense date.
I don't remember which one was first, Your Honor. I'm sorry.
Oh, it's okay. Who's here from the state? Mr. Reed.
I am, Your Honor.
Mr. Reed, how long will it take for you to file a petition?
If we've received it from JPD today,
Well,
I can send that over right now, Your Honor.
so Mary, let's set this for a motion to modify in 11 days. And John, I'm sorry, but it's like literally 2 days after he gets on felony probation that he picks up an assault case. So if you really did it, then, I mean, I don't even know why we're wasting our probation officer's time, right? I don't even understand. Yeah, so Mr. Elliott, I'm gonna let you know, it's very possible that this is the quickest probation that we've ever had here in Tarrant County. We'll find out if you violate probation, whether I should give you another chance on probation or if I should send you to TJJD. All right, so in the meantime, I'm gonna go ahead and detain you. Thank you.
Thank you. Your Honor.
Judge Kim,
Yes,
would you mind, just based on that last comment, maybe ordering a placement searches?
how long, Ms. Lopez, how long do you think you should do a placement search?
Oh, I'll send the packet over right today, Your Honor.
Okay,
Then I'll get back to Mr. Adler on how much time in the court.
I'm just wondering, are we talking days or weeks?
I mean,
We have to wait for a psych eval.
yeah, we have to wait for a psych. That would take
I
time.
think we had a psych eval in one of the two counties, Your Honor, already.
Yeah, let's go ahead and do that.
Okay, thank you, Your
Thank you,
Honor.
Judge.
We'll do a placement search and a psych eval if it's needed. All right, thank you. Thank you, Mr. Adler.
Thank you, Judge.
So Marquez Gaither.
Your Honor, and Miss Barker is supposed to be on here too. He's the OCOK worker, but I don't see her. And she said you are here, okay.
Ms. Parker. All right, so I think we just saw Mr. Gaither. Is it yesterday or the day before?
I'm sorry.
Mr. Gaither, we saw him like yesterday or this week? We just saw him,
I
right?
sent a progress report to you earlier this week about issuing a warrant for his arrest because he had 2 serious felonies maybe coming through.
Right.
He actually came in right when you were signing the warrant.
That's right. Okay, we had a schedule for detention. All right, Mr. Gaither, this is a detention hearing. I'm deciding whether to keep you here or to release you. If I keep you here, you have to see a judge every 10 days while you're here. Mr. Berger is your attorney. And you do have a right to remain silent, but if you give up that right, nothing you say at a detention hearing can be used against you at any other kind of court hearing. All right, so a pending case for assault, family violence, and now it seems like you are the subject of investigation of some serious felonies. And you also ran away from a CPS placement. So, the assault family violence case is, he's on DPP for that, is that correct?
Yes, Your Honor, and it has been reopened.
Okay, it's been reopened. So now we have the case. All right, so Mr. Gaither, you had that chance with deferred prosecution, but it looks like by running away, you kind of blew that one. So now you have the case looking at the felony. You understand you can be committed to the Texas Juvenile Justice Department because of that offense, if it's true or not. So Given the serious nature of the allegations that he's looking at on the new cases where he's a subject of investigation, I'm going to hold on to you a little bit, Mr. Gaither, just to make sure that the community is safe before I release you. We'll see at the 10-day hearing whether or not the investigation went through or not. All right, Ms. Peters.
Thank you, Your Honor.
Okay, all right. Thank you, Mr. Gaither.
Thank you.
Thank you, Judge.
Roger Jones. All right, Mr. Jones, I'm Judge Kim. This is a 10-day hearing. Deciding whether to keep you in custody or release you. If I keep you, you have to see a judge every 10 days while you're here. Very familiar with your case. This is the homicide while you're
He'll be back
at
next
your
week.
friend's house.
Wednesday? What is
So, yeah, and your level one standing today. Gotta ask Mr. Nava, what happened was behavior level dropped.
Your Honor, it says that you're just not following instructions and talking the day before. You've just been going up and down from 1A.
Okay, all right. Well, that's not, I mean, stuff like that happens. All right, Mr. Jones, your trial date was set for March 1st, 2021. However, the Supreme Court just issued, the Supreme Court of Texas issued another order saying that we're not to have any jury trials until at least April, right? So, so your trial will not go in March.
Judge,
Yes, sir.
I'd like to make a request to release him on whatever condition you choose to put. I'm concerned with the fact that the companion case is been released. They're charged with exactly the same thing.
Well, under law, they're charged with the same thing, but not the same acts.
I don't understand. What do you mean?
Well, the allegation is Mr. Jones actually pulled the trigger that killed somebody while the companion was just part of the planning.
Well, I mean, what I'm saying is that they're both, we don't know how that will proceed, but they are both standing the same charge because all you know is just the facts you just read.
And if I remember correctly, this is the one where Mr. Jones ran home, allegedly ran home, and the father helped conceal the weapons.
No, the companion father, not Mr. Jones.
So Mr.
Mr.
Gallo,
Jones was, yeah, Mr. Jones was a guest in Mr.
no, what I'm saying is after they both left the scene, and then when the police went to investigate,
All right.
the father for Mr. Jones's father refused entry, refused cooperation, and some of the weapons were concealed.
Your Honor,
I don't know that that is the case.
Roderick's father's not in the picture. I believe it is his brother, but the name's listed as Rico. I'm not 100% sure if it's his brother or if it's just someone related to the family.
See, Mr. Anigi, I mean, so we're at 270 days in detention, and that bothers me. Here's the main difference between Mr. Jones and Mr. Gallegos, is that Mr. Gallegos was very forthcoming with the police. To me, it shows a different level of criminal thinking and avoiding culpability, while Mr. Jones, well, he's certainly entitled.
That's what I was going to say, Judge. Since when has it become a critical issue to not talk to the police?
Well, it's an issue for detention, not for adjudication.
But Judge, he has proved himself since he's been in detention. For most of the part, he's been left with understanding. I don't see why not talking to the police should be something that should be held against him for release from detention.
Because the decision is whether it's a danger to himself, to the community, likely to return to court.
Somebody is trying to assert his right not to talk to the police would be something that would be considered whether to release him or not, Judge? I don't think so.
Yeah, for detention it is.
Okay.
Yeah, for detention.
Judge, this is my problem. I'm having a hard time explaining to the parents why the other guy is released. I understand what you're saying, Judge, but to an ordinary layperson, they are charged with the same thing. Why the other one released? Why is my son not released? And I'm having a hard time explaining to her that it's discretionary, as the judge said. But I do agree with her that it doesn't look right to, members of the public that they are charged with the same thing, but one is released and the other one is not. That's the problem I'm having.
Is that Mom here?
Yes, I'm here.
Mom, I want to explain this a little bit to you. So like in an adult setting, there's a presumption of innocence, okay? And people are entitled to bail no matter what. Even if you make a full confession on everything, you're still entitled to bail. That's guaranteed by the 8th Amendment of the United States Constitution. Juvenile matters are a little bit different, all right? Juvenile matters are focused on they understand that children think differently, they behave differently, they have different patterns. And so the idea is whether it's releasing the child is a danger to the community is a factor. That's not a factor in denying bail to an adult. You can't deny bail. Even if a person is, you could have hypothetically a 10-time drunk driver, a huge danger to the community, but they're still entitled to bail, right? It's only about whether they're going to appear in court or not in the future for the adult system. For the juvenile system, one of the things the court has to consider is whether the child is a danger to the community if they're released. And one of the factors that I consider, and there's no rule on this by law, every judge is different, but one of my factors is how culpable or how forthcoming was the child, because the more a child is open and candid with law enforcement, with adults, with everything, that tells me that the child is willing to accept more supervision, willing to accept responsibility. The more they try and conceal information or get away with a crime or what we call criminal thinking, the more of a danger they are to themselves or the community, because it shows that they're making efforts to not be responsible, but in fact to get away with their crime. Okay, and so it's a different thought process for juvenile matters versus adult matters. All right, I want to make sure you understand. And so the level of involvement in adult matters, you really look at, like when I set a bond in an adult case, I really look at the offense itself and not so much the facts. In the juvenile case, I look very much at the facts and not so much the offense. So even on misdemeanor offenses, here's a great example. If a kid has a deadly conduct discharge of a firearm, which is just a misdemeanor offense, I generally always hold that kid because a gun was used. But they could be arrested for felony evading with a motor vehicle, and if nobody was placed in danger, I generally let them go at the very first court setting, right? So one's a felony, but I let them go quick because there wasn't a gun involved. There wasn't necessarily a huge danger to the community. But when somebody's shooting a gun inside a city, then there's a huge danger, so I tend to keep them. So do you understand how there's a balance? For me, it's not necessarily about the offense, but it's really about the facts that have been relayed to me. And so that's my hesitation. Roderick, I'll be honest, I've been a little bit surprised. His behavior level has been so good compared to the offense that he's looking at. But Mom, I hope you understand why I'm very, very cautious with both Roderick and his friend, Lucas. But why I'm a little more cautious with Roderick, because the information given to me puts him in a much more, I guess, dangerous activity. Does that make sense? Like, I'm not asking you to agree with me. I just want you to understand what I'm thinking.
Yeah, I understand what you're thinking, and I feel where you're coming from. But I'm his mother. If I have to leave my job to be there for my son, just for him to get a chance to come home.
And I have
I
not,
would do that.
you were here, I think you missed once maybe?
Yeah, I work Monday through Friday.
I think you missed one time, but every other time for 9 months, you've been here once every other week.
I just want a chance to prove that I am not just gonna let him do nothing. Just give me a chance to show you that I can be a mother, and I would show you I would quit my job to be there for my son, to do whatever it takes, whatever you put him in, to whatever I have to do, I would do it. I will prove to you that I will be that mother to really stand up and do whatever it takes for my child. I want my son home.
Right.
I will do whatever a mother has to do to get him there. If you will give me that chance to do that. Just give me a chance to prove that I can be there for my son as a mother.
Right.
As a mother point of view, not as a, I understand this is a serious case, but give me a chance. Give me a chance to be a mother to my child, child.
And Mom, by you being here consistently and having the right attitude with me, you've never been disrespectful to me. You've always shown up on time. You've always been appropriate for court. I'm just letting you know we're at that point. Like, I had no compunction about holding him until fairly recently, within the last month, 2 months. Okay, so I'm on that process there just because of the facts given to me on this offense. I'm not quite there yet. Okay, but you probably noticed when this first started, I wasn't even considering releasing him. Right, I wouldn't spend the time to have the conversation with you or with your son because it was not gonna happen. I wasn't gonna release him. I am seriously contemplating this now. I just need to be confident because somebody did die out of this transaction that the police could place your son with. Okay, and so please don't lose faith in your son or with me. This is the hard part about my job, is because I have one chance to be wrong. And if I'm wrong, then somebody else can die. And that's my hesitation. Okay? So I hope you understand. I'm not asking you to agree with me. I'm just asking you to understand where I'm coming from. Okay?
So just to make sure that I understand, is it because he refused to talk to the police, or is there any other information the judge is looking at?
No, it's a factor. I'm looking at long-term how he's behaving. And what also is basically what Roger is trying to do is kind of run out the clock, right? He's trying to run the clock so that I am so annoyed with the idea of him being in here every day that it undermines the notion of fairness, because we are not having trials because of COVID. So if he keeps his level of being level 1-0, I understand the occasional drop to 1A, but if he's doing well, Mom's here, he's respectful, she's respectful, and eventually the number of days that he's here will get to the point where it offends any notion of justice to keep him here. That's what happened with Lewis Parker, right? It was a capital murder, but eventually I said it's just not right to keep him here any longer. So that's really my thought process of where we're going.
Well, I don't know if Lewis Parker has a companion case. It just doesn't look right to me, Judge.
Between Mr. Jones and Mr. Gallegos?
Yeah, I mean, what's the difference? I don't see the difference, Judge.
One was the trigger guy.
We don't know. That's why the case is set for trial.
Yeah, that's based on the report that I have.
Well, the report is not conclusive, Judge, because I have information you don't have that doesn't make the report conclusive on who killed the other guy. I just got that actually two days ago.
Right. No,
So, and you don't know that.
I only know what I'm given by the juvenile probation.
That's why it's probable cause. It's not something that one should take a lot of faith in, because it will change.
Right.
Did you ever mute it or move volume?
So 5401C. At the detention hearing, court may consider written reports from probation officers, professional court employees, or professional consultants, in addition to testimony of witnesses. If it's written, then attorney gets it. And then E talks about the conclusion, and 4, dangerous to himself or may threaten the safety of the public if released. And so what this is based upon is considering the report provided by probation officers under C, I'm applying that to E4, saying if he's alleged in the report to be the person who pulled the trigger, then that would give me concern about he's a danger to himself or the community. And threaten the safety of the public to himself or may threaten the safety of the public if released. Now I am weighing this against 8th Amendment cruel and unusual punishment considerations, but I don't think, that's not explicit. I think that's me just being devoted to the Bill of Rights. Because that's not officially one of the factors I need to consider how long a kid's been here. So I feel your frustration, Mr. Energy. I'm frustrated with this one as well.
Actually, I'm not frustrated, Judge. I'm just concerned about how it looks. It doesn't look good. I understand what you're saying. All these legal distinctions, the mom doesn't understand all that. All the mom knows that my son and this boy, my son went to this boy's house and they did something bad. This boy was in detention with my son and all of a sudden he's released. My son is not. That's all she knows. And there is no difference in terms of what they have done. I mean, she doesn't see any, I don't think any layman will see the difference the court is trying to make. And because everything is so inconclusive at this point, that's why it's probable cause.
Right.
And the standard that the court is, because the last detention hearing we had, Judge, I was actually wanting to know where the court is going until I realized the court released the other guy. So I was thinking the policy of the court is consistent with what the nature of the offense, the gun used and stuff, which is why the court held both of them until last week when one was released. I understand all the distinction the court is making. They're all legal points, but the factual point to, like I said, an ordinary person is like, Lucas was released, Rodney is not.
It's not fair.
Sure. Well, Mom, hopefully you understand what I explained. Given the information that I have that the law provides, it places your son at a higher level of bad behavior and culpability. And so that is why I'm more cautious than the co-defendant, co-respondent. Okay. So yeah, I'm just a little more cautious on this one. All right. So Roderick, keep up the behavior level, because I'm telling you, if you're level 3, I wouldn't even be considering it. If you're level 2, it wouldn't be a hard decision for me to make. The fact that you're behaving well, the fact that your mom is here, that is what's making my decision difficult. Okay? So I know I'm giving you discouraging news, but I don't want you to be discouraged. Hopefully that makes sense. All right. Thank you, Roderick.
Thank you, Judge.
Thank you, Mr. Aniji. Ashavian man. Is somebody here? Who's next door to David Ainsley? Is anybody? Okay. I have a David A in the waiting room, but it didn't put JPD by his name, so I'm assuming it's not him. But if it is, then I'll let him in. All right, Mr. Mann, are you here?
No, sir, no one is here for this detention hearing.
Oh, he didn't show up?
He didn't show up, but I also have to state, I don't believe he has, well, I can say affirmatively, he doesn't have notice of this detention hearing.
Oh, okay, well, let's just get him notice and put him back on. I don't want to issue a DTA if we can't verify that we give him notice.
Just to be thorough, we have no good phone number for the family. One number just gets a system message no longer in service. The other is to someone else at this point. He's not enrolled in school. And
So did he,
efforts to communicate with them, but
so they had contacts with us before?
yes, sir, back in June when he was arrested.
And were they informed that if they had a change of address or phone number, they would have to contact us?
Yes, sir.
All right, then let's get that DTA form.
All right.
All right, thank you.
Judge,
Yes,
that is David Ansley trying to get in, Judge.
okay. Kevin Garcia, no, I'm sorry. Twan Stewart. All right, Mr. Stewart, I'm Judge Kim. This is a detention hearing. When a kid's brought in, you have to see a judge within 2 days. I have to decide whether to keep you or release you. If I keep you, you have to see a judge every 10 days while you're here. You have a right to remain silent. You have a right to an attorney. And Mr. Pearson is your attorney. Good morning, David.
Good morning, Your Honor. Thank you.
All right, so Mr. Stewart, you were here last February for an assault bodily injury, which you got a supervisory caution for. And so yesterday you were referred by police. Well, no, yesterday there was a referral saying on January 7th, police were dispatched for a shooting call. Several black males running through apartments. Witnesses heard gunshots, found bullet holes in one of the walls. One witness said he heard shooting, heard a bullet whiz by his head. Witness said after the shooting appeared the suspect vehicle had exchanged gunfire with several black males. A couple weeks later, there's surveillance. Video showed Twan and two unknown people walking through the apartment. A Civic stops. Twan and one of his companions approach the vehicle. They get in the car. Twan appears upset, seen throwing his arms in the air. Companion gets out, draws a weapon, gets behind a vehicle, fires at the vehicle. Then they leave and returning fire back at Twan. So verified you through your school. Instagram account indicates that you may be a member of the Trench Gang and showed you wearing what seemed to be the same clothing as the shooting. And you're positive for weed. So, all right, Twan, I don't know if you remember detention hearings from before, but I have a big deal when kids come to kids and guns. So whenever a kid is caught with a gun, I generally always hold them, unless it's something like, the parents are like, that's my gun, or it's a mistake. And if they use a gun, I'm very, very slow in releasing them. So I'm going to detain you. I see your hand raised. If you have a question for me, I don't mind answering your question. If you want to tell me something, I'm pretty positive Mr. Pearson does not want you to tell me anything. All right. So do you have a question for me, or do you want to tell me something?
A question.
Okay. So go ahead and ask your question.
No, no question.
You don't have a question.
I was going to ask something.
So I'm kind of losing you. Do you have a question for me, or you do not?
I do not.
Okay. All right. All right. So get your behavior level up to 1 outstanding. That's what gets me considering whether to release you or not. But at this point, whenever kids are involved with guns, I generally always hold them at the beginning to make sure it's safe to release you to the community, both your safety and the public safety. Yes. Do you have a question?
Sir, I'm just going to tell you it was a mistake.
Hold on. Hey. Your attorney doesn't want you to tell me something, but if you have a question, so a question starts with who, what, when, where, how, why. Right, Mr. Pearson, it's okay for him to ask me a question?
Yes, Your Honor, but you're correct in assuming that I don't want him to make a statement or a comment, but at least till we've had a chance to visit in person.
So do you have a question?
So at first I was going to ask you, am I available for ankle monitoring?
Okay, no, I understand. And if I release you, I may or may not do ankle monitor. That really depends on whether you have a history of running away, skipping school, things like that. So that will be something I'll consider later. Right now, I have to make sure, based on your behavior level, whether it's really safe to release you or not. Mom, do you have any idea where this gun came from?
No, I do not.
Okay. Yeah, so I mean, that's the thing. If it was like mom's gun and we knew that, if a kid took the parent's gun and the parent's like, we have it back, it's gonna be locked, we know it can't be taken again, it makes me feel safer, right? But if a kid's getting a gun from the streets, then I gotta worry if I let you go that you'll just find another gun. You see what kind of, I'm not saying it's gonna happen, I'm saying those are the kind of things that I think about, okay? So at this point, get your behavior level up, show me that you're respectful, that you can follow the rules, and that tells me to give you a chance to let you go back to home to mom, because I'm pretty sure mom didn't want you to have a gun, if it's true. Right.
You
So,
said,
do you have another question or do you want to tell me something?
this question.
Okay, what's your question?
You said level 1?
One outstanding.
Yes, sir.
All right.
Next time you see me on level 1.
All right, thank you, sir. Thank you, Mr. Stewart. Thank you, Mr. Pearson. All right, at this point, I'm going to turn the docket over to Judge Porter.
Thank you, Judge Kim. All right, are you Mr. Garcia?
Yes, sir.
Mr. Garcia, my name is Judge Porter. We've met before. The law says when you're brought into detention and initially detained, you must see a judge every 10 business days thereafter. This is your 10-day hearing. You have the right to remain silent. You also have the right to an attorney, and your attorney, Mr. Adler, is here. The court has previously found that probable cause exists to believe that you engaged in delinquent conduct sufficient to warrant your initial detention. The purpose of this hearing is to determine whether you should be released to a parent or guardian. Mr. Garcia, you and I have talked multiple times about what your level needs to be in the back before I can even begin to consider whether you should be released. You're not there yet. You're still on level 3, aren't you?
Yes, sir.
What do we got to do?
Detain me.
All right, that'll be the order of the court. Thank you, sir.
All right. Have a good day, though.
Get your behavior up.
I got you.
Yeah, you told me that last time. All right. Brian Hernandez. Good morning, Mr. Sierra.
Good morning, Judge.
Are you Mr. Hernandez?
Yes, sir.
Mr. Hernandez, my name is Judge Porter. The law says when you're brought into detention and initially detained, you must see a judge every 10 business days thereafter. This is your 10-day hearing. You have the right to remain silent. You also have the right to an attorney, and your attorney, Mr. Sierra, is here. Does he have a parent or guardian here?
Yes, Your Honor. His mother is in attendance.
All right. I see mom on the screen now. Okay. You were previously placed on probation for burglary of a vehicle, and your new referrals are for unauthorized use of a motor vehicle and evading arrest or detention using a vehicle. When you were brought in, you were positive for amphetamines and marijuana and methamphetamines. Mom, does he take any prescription drugs? Mom, are you there?
Spanish.
Oh, okay.
She only speaks Spanish, Your Honor.
Okay, thank you.
Would you like me to translate, Your Honor?
Do you mind, Mr. Sierra?
No. Señora, ¿está su hijo tomando medicamento en este momento?
No.
No, Your Honor.
Okay. All right, Mr. Sierra, what are your thoughts?
Your Honor, I've been in communication with mom and the client. If you were to consider his release, putting them in school would be their #1 priority. And I ask that you release him, Your Honor. He is a level 1. I don't foresee any issues in the future if you released him.
School where?
The problem they have, Your Honor, is the mom called the school and said that she had asked for assistance and waiting for them to come back. And I told her that her son being in school is the equivalent of paying the light bill. There has to be more of an urgency and a priority. And she understands that now. And I specifically, I told her and how the court would look on an issue like that it's very big. And she assured me that as soon as he got out, and after speaking with my client, he said that he would also make that his priority if released, Your Honor.
All right. I think that's putting the cart before the horse. I want him enrolled in school, and then if you're still in level 1, I'll consider your release. But we're going to make sure he's in school, and while he's back in detention, I know he's going to school. So
yes, Your Honor.
Where I am. So I'm sorry Mr. Hernandez. But for today, I'm going to order you continue to be detained. Mr. Sierra, if you will express to mom that she needs to get him enrolled in school and bring proof to the probation officer. And then as long as Mr. Hernandez is level 1, I will consider, not a promise, but I will consider his release. Okay?
Yes, Your Honor.
Thank you, Your Honor.
Señora, ahorita acabando la audiencia, yo le marco por teléfono, ¿ok?
Okay. ¿Tienes preguntas? Okay, gracias.
Thank you, Your Honor.
Malachi, Blake, Lester. All right. I thought there's Dad.
Yes.
All right. Are you Mr. Lester?
Sir.
Mr. Lester, pull your chair close to the computer. Sit up straight for me. Talk nice and loud. My name is Judge Porter. The law says when you're brought into detention and initially detained, you must see a judge every 10 business days thereafter. This is your 10-day hearing. You have the right to remain silent. You also have the right to an attorney, and your attorney, Ms. Sherman, is here. We'll go ahead and let her turn her microphone on. The court has previously found that probable cause exists to believe that you engaged in delinquent conduct sufficient to warrant your initial detention. Ms. Sherman, how is the placement search going? Do we know?
I do not know, Your Honor.
Mr. Lewis, have we gotten the site completed?
No, well, the site has been completed, but the report will not be due back until Monday, and the placement search can't begin until the psych eval is in hand.
Okay. What are your thoughts, Ms. Sherman?
Well, I guess we're kind of at a standstill, Your Honor. I mean, I don't think there's anywhere to put him right now, pending the psych report.
Okay. All right. Mr. Lester, what's your level in the back?
2A, but I'm probably going to be 3C tomorrow because I stayed in my room.
Okay. Ms. Sherman needs you to get to level 1 outstanding. Here's why. I had a kid before me this morning. He got denied placement, any possible placement opportunities. I mean, there were 0 possible placement opportunities because he was level 3 in the back. I don't want that to happen to you. Ms. Sherman and I both want you to get to level 1 outstanding. And that way, Mr. Lewis is put in the best possible place to find the best possible placement for you, if that is indeed where this case is headed. That's not a promise. That's not a guarantee, but you want to have all the options available to you, and that will help you. Okay.
Yes,
Yes, Mr. Lester, do you want to ask me a question?
Yes.
What's your question?
If I was denied placement, where could I go? Would I just stay here?
No, you can't. We don't want you to stay in detention forever. We will find, assuming that that these new allegations are true, then we would find some place to help you out. And there are a whole bunch of different options, the worst of which could be Texas Juvenile Justice Department. But they have everything in one location to help you. They've got psychologists and psychiatrists, behavioral therapists. They've got a great school, and they can help you in meeting everything you need. But that's the most drastic option. But to put yourself in the best possible situation, you want to get to level 1 outstanding. And that means when the staff tells you you need to get up and get going in the morning, you got to do that for me. All right. Can you do that?
Sure.
All right. Now, as for today, I have to order your continued detention because you're level 2. But between now and our next detention hearing, I want you to work on your level for me. Will you do that?
Sure.
All right. Thank you, sir. Make it happen. That'll be the order of the court.
Thank you, Your Honor.
Thank you, Ms. Sherman. Okay. Aaron Israel Martinez Ortiz. Good morning, sir. Do you prefer Mr. Martinez, Mr. Ortiz, or Mr. Martinez Ortiz?
Mr. Martinez, sir.
All right, we'll make that happen. Mr. Martinez, my name is Judge Porter. The law says when you're brought into detention and initially detained, you must see a judge every 10 business days thereafter. This is your 10-day hearing. You have the right to remain silent. You also have the right to an attorney, and your attorney, Mr. Beaver, is here. Do you see him on the screen?
Good morning.
Yes, sir.
Okay. Mr. Beaver, am I remembering this correctly, that this was the case before me recently?
Yes, Your Honor.
All right.
And Mr. Nava told me that the hearing is scheduled, or the exam is scheduled for February 3rd.
All right. Mr. Martinez, how you doing in the back?
Good, sir.
Awesome. What's your level?
1-0, level
1.
one.
Outstanding, right?
Yes, sir.
Good job. Have you been able to talk with your attorney while you've been in detention?
No, sir.
Okay. And I'm sure that there'll be a point where Mr. Beaver will want to talk to you. And so if he calls you in detention, make sure you talk to him, okay?
Yes, sir.
Okay. You're not in a quarantine pod, correct?
No, sir.
Have you been able to talk to your family?
Yes, sir.
How's that going?
Good, sir.
All right. As for today, I'm going to order that you continue to be detained today because I want you to make sure you're here for your doctor's appointment next coming up. And then after you complete that doctor's appointment, we'll look at things again, okay?
Yes, sir.
You have any questions of me today?
No, sir.
All right, you keep doing the good that you're doing, okay?
Yes, sir.
Thank you, sir.
Thank you, Your Honor.
Thank you, Mr. Beaver. All right, Hugo Ramirez.
Council present, Your Honor.
Oh, hello, sir. How are you?
Great. How are you?
Better than I deserve. All right, are you Mr. Ramirez?
Yes, sir.
Mr. Ramirez, the law says when you're brought into detention and initially detained, you must see a judge every 10 business days thereafter. This is your 10-day hearing. You have the right to remain silent. You also have the right to an attorney, and your attorney, Mr. Meza, is here. Do you see him on the screen?
Yes, sir.
All right. I also see that mom and dad are here. That's great. Mr. Ramirez, now I already know the answer to this question, but I want to give you a chance. What's your level in the back?
1-0.
Exactly. So, and 1-0 stands for what?
I don't know what the O stands for.
Outstanding. Okay. And you have been level 1-0 since just before the end of last year. You were previously found, or rather, Judge Kim previously determined the probable cause exists to believe that you engaged in delinquent conduct sufficient to warrant your initial detention. And that had to do with the breaking in to a habitation, rummaging through a gun safe, and maybe a rifle or other gun was taken. However, the rifle has been recovered. Mr. Meza, what are your thoughts?
Well, Your Honor, I've spoken to my client, also his family. They feel that he's ready to come home. They're able to provide a secure environment. They're going to make sure he is going to attend school. Prior to this incident, he was taking classes at home on the computer, but they want to get him back in school as soon as possible. His family, his other 2 siblings miss him, and they would like for him to come home. Prior to this incident, there was never any other criminal history. So we feel that he should be back at home and actually back in school also.
Okay. Ms. Rojas, he's scheduled for court on Monday. Is that correct?
Yes, Your Honor.
Okay.
And also, Judge, the rifle was just an item that was allegedly stolen. It was not actually used in the commission of a crime. It was just an item that was stolen allegedly within the home.
All right.
So just to point out, it wasn't a gun that he carried that was with him at the time of.
Allegedly.
Yes.
Okay.
Well, I think I pointed out last time, Judge, his grades are fairly good. I mean, some C's, B's, and some A's. I mean, but on average, he's a pretty decent student, makes pretty good grades. So that's something reflective of his past prior to this incident.
Are C's good enough to get him into a really good college and then maybe law school?
Possibly. He works really hard moving forward.
He's gonna have to work harder than a C level to get there.
Mhm.
Okay. Mr. Reed, what are your thoughts?
Judge, on this case, we defer to the court.
Okay. Mr. Mazik, can you, I'm sure you've talked to the parents. Can the parents make sure that he's back to court on Monday?
Yes, Your Honor.
Okay.
I think his parents speak Spanish. I can explain to them if you'd like.
Por favor.
Okay. Hola, soy el abogado Mesa. Si su hijo salga hoy, ¿usted puede estar seguro que él va a atender la corte el lunes que viene?
Siento que sí.
Perdóname.
Nos hacemos responsables de que esté acudiendo a las cortes que pueda tener en el futuro.
He said they'll take responsibility that he does attend the courts.
Okay. ¿En lunes?
Sí.
This Monday? ¿Este lunes?
Sí.
Okay.
Yes.
So, Mr. Ramirez, if I let you go, are you going to promise me you're going to come back on Monday?
Yes, sir.
What happens if you don't come back on Monday?
I'll come back here.
But what happens if you don't?
I have no idea.
Yes. What happens is two bad things. The first bad thing concerns you. I can and probably will issue a warrant for your arrest. And then the next time you come back to Kimbo, you're going to be staying even longer than you have this time. The second bad thing concerns your parents. I could issue a warrant for their arrest that results in both of them being taken to the Tarrant County Jail. Do you want your parents to go to jail?
No, sir.
So what do you need to do to make sure they don't go to jail?
Come to court on Monday?
Uh-huh. And you see your attorney on the screen, right?
Yes, sir.
Something tells me his wrath is going to be even greater than mine if you don't come back to court on Monday.
Yes, sir.
Just a good guess. All right. Mr. Ramirez, I remember your mom and dad being here last time. I'm going to release you on the electronic monitor. Don't cut off the monitor, okay?
Yes, sir. Thank you.
Keep it on. Don't violate it. All right. That'll be the order of the court. Thank you, Mr. Meza.
Thank you.
Judge.
Thank you.
Okay, finally, no, we got two more, sorry. Joseline Saldana. Are you Miss Saldana?
Yes, sir.
Miss Saldana, my name is Judge Porter. The law says when you're brought into detention and initially detained, you must see a judge every 10 business days thereafter. This is your 10-day hearing. You have the right to remain silent. You also have the right to an attorney, and your attorney, Mr. Sierra, is here, or he disappeared from my screen. So Mr. Sierra may have had a computer problem. Mr. Adler, do you mind stepping in real quick for me?
Not at all, Your Honor.
Thank you, sir. All right. Ms. Saldana, you were previously found to that probable cause exists to believe that you engaged in delinquent conduct sufficient to warrant your initial detention for a previous referral. And now it's also been alleged you were brought in on a runaway. So, okay. Joseline, you are level 1-0, correct?
Yes, sir.
How long have you been level 1-0 this time?
For maybe 5 or 6 days.
Okay. Let me ask you a question. Given your history of running away, do you think 5 or 6 days at level 1-0 is enough to convince me that if I released you, you wouldn't run away again?
Your Honor, I need rehab. Not.
Okay.
I don't need to
Okay.
get released.
Well, okay. You know, that's a really mature thing to say. That's a very, very mature thing to say. And that's hard for sometimes something that even a 17-year-old to say. Oh, and before I forget, happy birthday.
Thank you.
But, you know, that's really mature of you. And that shows a lot of growth by you. And so, I don't know if anybody else will tell you, but I am proud of you for being able to show that kind of growth. Okay.
Thank you.
All right. I'm going to order you be detained today. I don't want to do it because it's your birthday, but I need to, right?
Thank you.
All right. Happy birthday. Enjoy the rest of your day. Be good. Continue to keep doing good in the back for me. Okay.
All right.
Thank you. And finally, Alexis Soto. Good. Oh, no, I have two more. I apologize. Okay.
He's coming, Your Honor.
Thanks. I hear the flip-flops. Good morning, Alexis.
Good morning.
How are you?
I'm doing good.
All right. My name's Judge Porter. The law says when you're brought into detention and initially detained, you must see a judge every 10 business days thereafter. This is your 10-day hearing. You have the right to remain silent. You also have the right to an attorney, and your attorney, Mr. Adler, is here. Do you see him on the screen?
Yes.
Yes, sir.
Yes, sir.
Thank you. All right. The court has previously found the probable cause exists to believe that you engaged in delinquent conduct sufficient to warrant your initial detention. You're level 2 in the back, right?
Yes, sir.
What do I have to do?
Detain me.
Yeah, why do I have to do it?
So I'm not a level 1 level.
Yes, sir. All right, that's going to be the order of the court. Get your level up for me, sir. Thank you. Good morning, sir. How are you?
Good, you.
Okay, my name's Judge Porter. I don't think we met before. The law says when you're brought into detention and initially detained, you must see a judge every 10 business days thereafter. This is your 10-day hearing. You have the right to remain silent. You also have the right to an attorney, and your attorney, Ms. Mills, is here.
Hi.
Can you say hi to Ms. Mills?
Hi, Ms. Mills.
All
Hi,
right.
Coy. How are you?
Good, you.
All right, sir. The court has previously found the probable cause exists to believe that you engaged in illegal conduct sufficient to warrant your initial detention. And you referred in for an unauthorized use for motor vehicle for allegedly stealing grandfather's truck. So he's been level 1-0 since the 11th. Is that Dad on the screen?
Yes, sir. Yes, Judge.
All right. Ms. Mills, what are your thoughts?
Judge, when he was brought in last time, he actually lives in Hillsborough, I believe. Dad was not ready for him to come home. Dad is a police officer. I believe stepmom works for juvenile probation. So they wanted him to stay here for a little while. I talked to Coy. I have not spoken with Dad recently. I'm not sure if Dad's ready for him to come home yet or not, but I know Coy is ready to come home, and he's done very well in the back. I believe he even has some certificates and things today. So I'm going to just defer to Dad at this point to see what he wants to do.
Dad, what are your thoughts?
I think he's ready to come home. We're ready for him to get home, but he's going to have to understand that we're not playing games, so he can't be going out and acting like that.
You think he needs to be on an electronic monitor, at least for a little bit?
Yeah, I mean, that'd be great.
Well, then we will make that happen. Coy, you by your behavior in the back for the last 10 or 11 days have proven to at least me that you know how to follow the rules. Now, I'm going to authorize your release today. It will be on the electronic monitor. Here's the deal. I expect you to maintain level 1 outstanding at home for your dad and your grandpa. You understand me?
Yes, sir.
Okay. You also have to come back to court whenever Ms. Mills tells you you have to come back.
Yes, sir.
Understand me?
Yes, sir.
If you don't come back when Ms. Mills tells you you have to come back to court, what can happen?
I come back here.
Uh-huh. And do you think I'm going to be so nice the next time?
No, sir.
And do you think your dad's going to be so happy to let you come home after only, a couple of weeks?
No, sir.
Okay. All right. I'm going to authorize this release on the electronic monitor. Dad, thank you.
Thank you, Judge.
Coy, don't let us down. Thank you, Ms. Mills.
Thank you, Judge.
All right. Anybody need anything else?
Thank you,
That
Your Honor.
concludes today's hearings. Thank you, everybody. Have a great weekend.